This is Michael Cowen, and welcome to Trial Lawyer Nation.
You are the leader in the courtroom, and you want the jury to be looking to you for the answers.
When you figure out your theory, never deviate.
You want the facts to be consistent, complete, and credible.
The defense has no problem running out the clock. Delay is the friend of the defense.
It's tough to grow a firm by trying to hold on and micromanage.
You've got to front load a simple structure for jurors to be able to hold on to.
What types of creative things can we do as lawyers, even though we don't have a trial setting?
Whatever you've got to do to make it real, you've got to do to make it real. But the person who needs convincing is you.
Welcome to the award-winning podcast, Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
We're going to start a new feature on this podcast. It's Ask Michael and Mallory Anything. If you have anything you'd like to ask either Mallory or me, we're going to start doing an episode every couple months where we're going to answer your questions. So just send them in to me at michael@cowenlaw.com, and Mallory and I will answer them. Anything from, legal strategy, marketing management, anything else in life you want to talk about, we'll be glad to talk about it with you. Again, ask Michael and Mallory anything. Just send us an email. We'll be glad to answer your questions. Welcome to today's Trial Lawyer Nation. I am joined by my law partner, Sonia Rodriguez, and we're here to talk about a fun trial we had in Austin, Texas, where we were able to get an $8.5 million verdict on a very disputed premises case involving a brain injury. Sonia, how are you doing today?
I'm great, Michael. How are you?
I'm fantastic. Before we jump in, as always, I want to thank our sponsor, LawPods. LawPods makes this so easy. They set it up. They make sure we sound good. They recorded it. They edit it. They help us market it. If you want to do a podcast, which is a lot of fun, I highly recommend LawPods. Okay, Sonia, let's jump in. So tell us a little bit about this case that we tried.
So as you briefly mentioned, it's a pretty hotly disputed premises liability case. And the unique issue in the case is that our client is a tech executive, a relatively high wage earner in Austin, Texas. And she made a fabulous recovery, by all accounts, made a fabulous recovery from a moderate to severe brain injury. And within 6 months, through her own willpower and commitment to getting better, was able to return to her work, which was a work from home tech job. But she was able to get back to work. So the challenge in that case was telling the story about what cognitive deficits she had against this backdrop of, her being back at work and being able to work. And so that was a big, challenge.
On top of the challenge of it being a premises liability case under Texas law, which is not the most plaintiff-friendly, we were able to navigate it, but not the most plaintiff-friendly. But let's start talking about the first challenge, which is we have someone with a brain injury, and you knew from interacting with her that she still had deficits. It is an art and a challenge to represent clients that have brain injuries because they have brain injuries. They can be harder to deal with. How did you tell the story, though, to show that even though this woman was back at work and making more money than probably most of the jurors, that she still had cognitive deficits that were worthy of compensation?
So one thing that we zeroed in on was what life was like before and how life has now changed. And the only way we were able to do that was some friends and family members who'd known Judy for a long, long time and would be able to recognize the real subtleties in her cognitive output. And, what they could describe, I think, ended up resonating for the jury. We had her best friend flew in from New Orleans, and he was able to talk about her sense of humor and how, they had this, real similar sense of humor and how he noticed that had changed. And it's a subtle difference and something only a good friend would notice. But I think it resonated for the jury. It helped having that perspective. Her brother flew in and he testified about her executive function. Obviously, he's not talking in those terms. He's not using the words executive function, but he's talking to the jury about her decision making. And I think that was critical. So we had a cousin come in from out of town, and we had one of our other best friends testify via Zoom. So, I mean, I think, all told, we had 4 or 5 damage witnesses who had a separate story to tell about our client's cognitive deficits and made them real for the jury.
Yeah, I think that was important. I think the other thing is, putting the work into context. We also had the deposition of the woman who's now her ex-wife. They were going through a divorce at the time. Was really powerful. And I think it really shows that while she was able to do the work, it was a lot harder for her to do the work. She had to have all kinds of extra notes to herself about things to do. She had to take a lot more breaks. It took more hours. And at the end of the day, she's just absolutely exhausted and drained, as opposed to being able to enjoy her time off and her evenings because, keeping up with the job was just killing her. But she was still doing it. I've always found that jurors will give more money to someone who fights through and to get back to work than the person that just says, I can't do it and stays home.
Well, I think it was critical in that case to bring the neuropsychologist to explain, kind of put the puzzle pieces together, because at that point, the jury had heard from family members about these odd things they'd noticed. And then when you had the neuropsychologist on the stand, I think that helped the jury kind of put the puzzle pieces together and understand the why behind the behavior. I thought that was good.
And I think mixing in the physical injuries with the TBI also, I think, helped a lot, because the fact that she still had back pain, she still had neck pain, she still had headaches, and all these things combined to really drain you and make it harder to enjoy your life.
I thought it was important, too. I think you brought that up with the neuropsychologist and maybe even the life care planner about how our client's ability and capabilities were pretty high before, and her ability to manage stress and her ability to manage multitasking and things like that was at a pretty high level before. And that she's able to get by and still do it is probably also a function of her, high ability beforehand.
Yeah, I think that's really important. It's not what you have, it's what you lost. And so if you were, before you were 99th percentile and now you're 75th percentile, you still lost a lot, even if you're above average. And I think that was something that was also important to put out there. I think another thing you did really well in telling the stories is you got some really good, it took a lot of work, I know, on your part, but you got some really good photographs of our client doing things that she loved with people she loved before. And I think, just showing that visual proof that these are real stories. These things are really happening. And it also, I think, really helps lay witnesses tell a story when they have a photo to use.
I think so, too. And, you really don't always need just a photograph of the client doing something. You can have a photograph of the boat that she, or the sea-doos that she would ride on with her kids.
Yeah.
And being able to tell the story of what she's now lost and can't do anymore, I think is important for the jury to understand.
And I like that you got really specific stories. I mean, there's one, for example, instead of just saying, well, she can't remember things that she used to remember, the other is like, I was doing some, because she would fix up homes also in her spare time. And I think she rented them out. Is that right?
She had multiple homes herself, and so she was renovating homes for herself.
Okay. Well, she had her friend who's also a handy guy, contractor. And before, she would always know what tools to hand him. And then you had the very specific story of like, he's up on the ladder because she can't get on the ladder anymore. He's asking for things and she can't figure out what they are.
I thought that was pretty powerful, too. I mean, and that was a genuine story after visiting with him for several hours about, okay, let's talk about all the ways that you've seen differences in behavior. That one kind of stuck out to me as alarming. And I thought the jury would think it was alarming, too, because it was the moment that he realized that things were not the same with her. And, he was describing how he was standing on a ladder, kind of hollering at her, hand me this tool or hand me that tool. And just the look of confusion on her face was what he described to the jury. wasn't like her before. She would be able to pick out the tool and hand it up to him. And now she didn't know what tool he meant or what he was needing or why.
Yeah, and that was really powerful. But I think just that it's not just saying she doesn't remember things anymore, but telling a story is just so much more powerful. It really brings the jurors in more. And, in this case, it worked. I mean, the fact is we were able to bring out the truth through those stories. The other thing I thought that went really well is, she, like everybody else that's, in their 50s, she had some pre-existing conditions. Her MRI, they have an MRI of her spine from like 10 years before that, not necessarily symptomatic, but looked a little gnarly when you looked at the MRI films. And one thing you did is you went and got her prior medicals, which was smart and not just trying to wish them away. But then our life care planner, who was a physician life care planner, actually went through and for like the 5 years before, wrote up how many visits, how many providers does she have for the back, for the neck, for headaches, and then afterwards, how many does she have? So, for example, I think like neck pain, she had 3 visits in 5 years for neck pain before, and then she had like 90 something in the 3 years after. And then you just made a simple graph, and it's just so clear that it wasn't that big of a deal before, and it became a huge deal after.
I thought that was pretty brilliant. And Michael, what are your thoughts on how to use something like that if you have a life care planner or a treating doctor who doesn't have the time or energy or resources to create those pretty visuals for you?
Then do it for them. But the thing that, and of course we ended up paying him a ton of money, but you do have to have someone go through all the prior medical visits, because if you leave any out, the defense is going to slam you on it.
Right.
So you do have to get someone to make sure you have all the records and make sure you get all the records the defense got in case they got something you didn't get. We try our best to be thorough, but just in case, and make sure you have all those visits listed and what symptoms they are on each visit. And then you could do that. But the doctor you're working with has to at least go through those records or a summary of the records and be able to point that stuff out, or they're going to get killed on cross.
That was my biggest fear, was that there was that chart was a beautiful chart, right? It was just a bar graph of treatments or complaints before and then complaints after. And so it was scary to me the whole time, thinking that somebody was going to pull up, something to suggest that bar graph was wrong. But he was exceedingly thorough in it. And I even asked him if he was using some AI tool to create that chart, and he did it himself. So it was impressive.
No, he actually gave me his Excel spreadsheet because he'd actually misspelled after, and I had to go, because he was doing the graphs through Excel, I had to go change the Excel table to have after with only one F. But he literally just went on every single visit. He created a spreadsheet every single visit, and then what symptoms there were in every single visit, and then counted. It was great. It was, a lot of work. We had to pay him a lot of money to do it, but it totally was worth it, because that's really, I think, one of the things that won the case for us.
I think so too. I think when the jury could visually see that we were embracing the past. I mean, we weren't trying to suggest that she didn't have back pain or that she didn't have neck pain before. She certainly did. And I thought you did a great job going through each of those visits where she did have those complaints and put them in context for the jury. I thought that was great.
And I think that was really important too. For example, the defense had an orthopedic spine surgeon that said, well, she had prior back problems before, and that must be because of the herniated disc she had in the back. And so I was able to take the latest one, and I said, oh, this is one of the visits you're talking about where she had that back pain. Yes. And it says, starts with ovulation, ends with her menstrual cycle. You're really telling us that's from the spine? And he said, yes.
I mean, and then it's just keeping them honest,
And our juror was 9 women and 3 men, so probably not the best argument for them to make. And then the neck pain, I think, was related to shingles, and it said in the medical records it was related to shingles and went away when the shingles went away. So it's just really, reading that prior medical and embracing it, and also saying, though, look, she's in her 50s, she's going to have occasional back pain. And you start that in jury selection, who here has occasional, every now and then, aches and pains,
And the reality, too, Michael, was, the defense did bring up those MRIs and had them up on a screen bigger than, bigger
Yeah.
than me. I mean, it was a huge screen, and the jury was watching the defense expert go through those disc bulges one at a time, and there was no way to hide from them. So putting that in context, I think, was important.
Yeah, and I think we did some real judo law on that too, because I knew from prior depositions that in cases where there's only the MRI afterwards that it shows stuff. There's one famous study in the New England Journal of Medicine, and there's been some follow-up studies where they took MRIs of people with no back pain, and then they found all kinds of herniations and other things. And they try to get that to say just because you have something on your MRI doesn't mean you need surgery or you have any symptoms. And so I use that against them. Like, well, just because you have the MRI, there's these studies, you can have an MRI like this and have no symptoms. And then just through listening and through luck, I noticed that they made a big deal that she had something called a radiofrequency ablation. And after the radiofrequency ablation, 90% of her pain went away. I think 100% on one side and 90% on the other side. And I know that radiofrequency ablations are for facet injuries, not for disc injuries. And so, I asked him on cross, well, she had a radiofrequency ablation and the pain went away, didn't it? And that's for facet, and that means the pain's for the facet. So all the things you showed me on that MRI, those things aren't what was causing her pain, because the radiofrequency ablation would not have helped those things. And he agreed with me.
Yeah.
And so it took all of it away, I thought.
Well, I thought that knowing the medicine and you're knowing the medicine and being able to have a conversation with the doctor about what the reality of what the medicine is, the radiofrequency ablations would have, if they were working, would have resulted in pain relief.
Yeah, and I think it really also just showed that they were being deceptive. And, it's you always want to show that the other side's being a villain, that they're being deceptive. And, you can't just say it, you got to show it. And I think when they take things out of context and cherry pick, I think that is one way to show that they're being deceptive.
Well, the pointing out the shingles and the ovulation, low back complaints, I thought that was really critical in showing that they were not bringing the truth.
Absolutely. And the bringing, and like I said, us embracing and being the first to talk about the priors made us the bringers of the truth. And I think that was just a huge, huge difference.
And, it doesn't come natural. I think most of the times plaintiffs' lawyers are so fearful of looking into the past medical because they're afraid of what they might find. But the reality is, if we don't do it and we don't analyze it and study it and are prepared to discuss it, then the defense will bring it up first. And so
they will. And there's these databases out there now where you can get, and I know there's supposed to be all kinds of privacy protections, but that's just not our world. And you can get all of someone's prescriptions for a period of years before the crash. You can get all their doctors. They saw all their doctor visits, the CPT codes. So, you're not going to hide anything from the defense in this day and age. And so either it and you are ready to embrace it, or you're going to lose your ability to put it in context. Because if we had told the defense she had never had back or neck pain before, we would have been dead.
Yeah.
But luckily we had those records, and we had a client that told the truth in depo, and we were able to make it really work for us. Another thing I did and was hard for me to do, well, let me go into why that's hard and how we get around that. So I think one fear we have is, if our clients ever had anything wrong with us, the jury's just going to think, well, they were already hurt. Even though we know that's not true. We know that you can have like minor aches and pains like everyone else has, and then get a lot more hurt and have it become something permanent and, something that's actually making a difference in your life. And I think it's really because people don't trust the jury. I mean, if you trust the jurors, that they're smart people that are going to see through BS and figure out what the truth is and do the right thing, then you can trust them with the whole truth. And so one of my mantras that, I would say every morning, and I know it sounds silly, but it really does make a difference. You've tried another case with me, and you can see the difference. It's like the jurors are good people. They're taking time out of their lives because they want to do the right thing. I can trust them. They will do justice. And I just tell myself that over and over again. And so then when the defense brings something up, I still have to do my job and bring them the rest of the story, but I also don't have to get upset or get scared. I just trust them. And
I think your mantra, it also helped Michael with our client's mindset. I mean, we were dealing with a client who had a brain injury and had her own fears and anxiety. But I think your mantra and your attitude going into trial with that positivity and trusting the jury was actually critical in helping her embrace the process.
Yeah, because we really had to talk her up and make sure she was ready to go in with a good mindset, because if she was defensive, she could have killed the case.
Yeah, sure.
And I think she testified really well. We were a little surprised, but
She
I
did.
think she did a good job.
She did a great job. I think, too, though, putting her on without a lot of buildup.
Yep.
I mean, there wasn't a lot of buildup. We weren't over preparing her. It was kind of like, okay, we're going to put you on now. And it was just, it made it a little bit easier for her to handle without, making it much more dramatic and worrying about it overnight. She didn't have that. I mean, it was kind of nice. I think it worked out perfectly.
Now, we had prepped her, but, part of it, I just had to really get her, like, we have these, you don't have to do everything. You have other people are telling a lot of your story for you. I want you to address these 3 things, and these are the only 3 things. And, of course, the other side gets to talk to you whatever they want to talk to you about, but I want you to just handle these 3 things. And then some of the things that the defense did, I think, really, like, for example, we didn't have her there for most of the trial.
Right.
We just had her there when she testified, and we had her there for closing. And so she testified. One of the things she was confused about, she thought she had a job interview that day, but it was really the next day. And, that's not something she would have. So she was all stressed out about thinking she had a job interview and she was supposed to testify that day, but it was really the next day. And then the defense lawyer, and I think he was making her point, like, well, why would you schedule a job? Because she had been laid off, and not because of performance, because of the industry. So, like, well, why would you schedule a job interview in the middle of your trial? And my first thought was because she's brain damaged, but
Right.
her answer was so great. She's like, because I want a job.
Right.
Like, I'm going to get a job interview whenever I can. And I think it just showed who she was, and I think it really helped.
It did. How long do you think you had her up on the stand?
Sonia, it's all a blur to me.
I don't think it was more than 20 minutes, Michael.
It definitely wasn't very long, because we really just had a few things that we needed to cover with her, and we covered them with her, and then we just trusted everyone else to tell the rest of her story. Because, I wanted her to talk about how she was trying to fight to get better. I wanted her to talk about 1 or 2 little bitty details. We didn't go through the whole story of what happened because it was on video, but 1 or 2 little details I thought were important. But that was really, really it. And had her talk about how much she tried to get better, how much she's fighting to get better, how much she wants her life back. And just really had her be the survivor, not the victim.
She had to trust, she had to trust us that we were going to get other friends and family members to give the portions of her life that she felt she needed told. And I think she had to trust us to not sit in the courtroom the whole time and supervise,
I think that was really hard for her. Because
she's
she was an executive. She's used to controlling. And so I think just, the way we spoke to her to get her trust, to show confidence was really important.
Yeah.
Well, what are some other lessons you took from this case?
Well, one thing that I learned from this case is that as a trial lawyer, you have to let go of this control issue that I have, and that we don't have control over a lot of things. And I was really proud of seeing you abandon some of the tools that you like to use at trial once we learned that we couldn't use them or they weren't working well for us. One example was Travis County has fabulous technology in the courtroom. But as you recognized very quickly and you abandoned it, some of the technology that they use, the Wolf, which I guess used to be an Elmo, now they call it the Wolf in Travis County, but the way it was positioned lower to the ground, it would work perfectly for me, but for you, it didn't exactly allow you to work it very easily. And you abandoned it.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. And now, back to the show.
Yeah, to use the basically the document projector, to write on it, I would have to turn my back to the jury and bend over. And unfortunately, I don't have a booty that is going to engender a lot of votes from our jurors for me doing that. It was awkward, uncomfortable, and also not the best view for the jurors. And so,
Well, you quickly abandoned it. You
I
know,
did.
you tried to work with it at first, and then once you realized that wasn't going to be something comfortable for you, you moved on and found another way. So
Also realized
flexibility was
I
important.
was blocking the screen when I was using it too.
Right.
I was too tall for the way they had it set up. Another thing is with the flexibility. I remember before trial, I'm getting in my mindset. I'm like, okay, because we had a big hearing. We had some big issues coming up about whether or not we could get in prior incidents of other people falling at this site where this woman fell into like a 10-foot steel bottom pit at a dump site. And so I had told myself, well, I have two ways to win this case. If I get in the priors, it's going to be, they knew it was dangerous. Other people got hurt. They did nothing. She got hurt. They're still doing nothing. You need to fix this was going to be my one theme. And I said, but if that doesn't work, I know that, as a general rule, even though she's not an employee, OSHA regulations are admissible in Texas to show the cumulative wisdom of the industry as to what is safe, because it's just as dangerous for a customer to be there as it would be for an employee. And it would be against OSHA regulations, because there's no fall protection, to have someone standing on the edge of this dump, dumping stuff off because of the fall risk. And so I said, well, the other one is it's too dangerous for their employees, and yet they have their customers do it. Well, we didn't get in the prior falls, and we didn't get in the OSHA regulations. And so both of my themes were gone in limine. So we just had to come up with another one.
We had to pivot. We had to pivot very quickly. And I think the rulings were very shortly before your opening statement. And so
they were. The rulings were made right before noon, and we picked a jury later that day. And we originally were going to do opening that afternoon. We ended up getting till the next day. But, I just had to, again, the self-talk and I think 10 years ago, I would have been in a state. I would have been like, okay, all my plans are gone. And, one of the rulings, the other similar incidents, and we did get some that happened afterwards. We can talk about that a little bit. But, the rule is you have to prove substantial similarity. The defense did a good enough job of playing dumb in discovery and saying, we don't remember any of the details. I don't know, that we, weren't able to prove exactly what happened in the prior falls. And so, we have to respect the judge's ruling. The ruling on the OSHA stuff, I respectfully disagree with her, but that's her ruling. And so two of the other mantras I did every morning, one was, the judge is a good person. She's making decisions on what she believes to be the facts and the law. I may not always agree with her, but I respect her and assume good intent. And I would just tell myself that over and over again. And the other thing is, I said, I will win the Judy Kent case no matter what. There is no other option. And I'd say that to myself like 10 times a morning. And the reason I did that is just I wanted to say, no matter what the rulings are, I'm going to find a way to win. My job, it's the judge's job to make rulings. It's my job to find a way to win under those rulings. And I never did that before, like saying I have to win the trial. I always thought I'd jinx it. And I just said, nah, I'm going to do it this time. I'm going to try it. And I think it really made a difference, because whenever she made a ruling, I was like, okay, we got to find another way to rule, another way to win. That's just, this is not a judge that wanted you to keep arguing something when she made a decision. She made that very clear. And so
did you have fun?
Did I have fun? Yes, I did have a lot of fun.
It was a fun trial.
Blast. I didn't get a lot of sleep, but a lot of fun. And this judge, I mean, she's a good judge with a good heart, but she definitely would interrupt us a lot and was very vocal in trying to coach us to be better lawyers. For example, she would interrupt a deposition while it was being played to tell us that we needed to cut more stuff out and to stop doing this. And then at one point, she required us to put the defense cuts and our cuts together. And then she starts yelling at me for what the defense had in their cuts. And I had to, not lose my cool and explain, Your Honor, I'm very sorry that the defense put that in there, but you told me I had to play that with theirs. If you could please let me play ours separately, because I knew what the defense was doing. They were putting a bunch of bullshit in there so that by the time we got to the good part, the jury would be bored.
Right.
And it worked, because I think because I kept calm, then she let me go back to doing it our way. And our cuts were much, much shorter. We were doing a lot of 15, 20-minute depot cuts.
Yeah, it was much more succinct with her help and guidance.
And so what did we do to keep the right mindset when the judge was giving us strong coaching, is how I'll word it?
Well, I think your attitude that the judge was trying to make us better lawyers.
Yep.
And just embrace the fact that we would be better lawyers by taking this in and keeping a positive attitude about it, I think was critical too. At least my maintaining my cool.
Yep. I even pictured her as Nick Saban, the former Alabama football coach, just saying he would chew people out, but he'd send them to the NFL. So it's like she's just trying to make us better. She wants to make this a better trial for the jury. She wants us to be better lawyers. And so I'm going to be grateful to her every time she chews me out, because that's her way of showing love and trying to make me better. And I even told her that, I think, a couple times.
You did tell her that a couple times.
And, I think that could have gone the wrong way. I could have looked like I was just being an ass kisser, but I think she took it as sincere after a while.
Well, I think you meant it as sincere. I
did.
think you really did truly embrace the idea that every time that she corrected us, it was to make you a better lawyer. And I really do think she felt that way. She was very protective of the jury, and she wanted to protect their time. So,
I 100% thinks that everything she did it because she believed that it was going to make the trial better, protect the jury, make us better lawyers. No doubt in my mind that that's true. But I will also say that, because we had to do so many, she made us re-edit our things, our videos multiple times. So I got so little sleep that trial that I had no ability to filter or be fake at that point.
Right.
I had to really work on the mindset work, because whatever was on my mind was going to be coming out. And
well, having a video guy at our fingertips ready to edit for us, and even willing to edit for the defense, I think was critical. And I think it showed some real sportsmanship by our willingness to do depo cuts for the defense on the fly, too. I don't know if they took us up on it, but
I think they did on one of them. And it wasn't just being a good sport. Also, I wanted to be able to play our depos in the order we wanted. And I was worried that if we didn't do the defense cuts for them, they just would say, well, Judge, we're not ready. Can we do this witness on another day? And then we get all mixed up and out of order.
Right.
Something else that I think was something I did for the first time, and I think it worked well, is, you always think when you're doing a cross-examination, what is the story I'm trying to tell with this witness? And they had a neurologist, and the story I wanted to tell was, don't listen to this guy because he's just a paid advocate. And so when I'm questioning him, I would ask him a very simple question. He would go on a 5-minute lecture, and it was very strongly being an advocate for the other side. And there was a little part of me that wanted to say, objection, non-responsive, Judge, he won't answer my questions. But I took a step back, I took a deep breath, and I realized every time he does this, he is showing who he is.
I thought that took a lot of restraint.
It did. It was hard.
I will tell you that you asked him a simple question about, have you ever been to a solid waste transfer station? And he went on and on and on and about how he'd served in the military, and I just went on about his life experiences.
Yep.
And I just don't know how you showed that restraint, because I thought my head was going to pop off.
Yeah, it's just trusting the jury. Just telling myself, okay, he's showing who he is. I trust the jury is going to figure that out. I trust they're not going to be he's going to say this crap anyway. And that they're just not going to be so spellbound by him that I can do it. And I think he was very ineffective because of it.
Yeah, he was. There were a few things that he said that just had nothing to do with your question at all. Was just very self-serving, both as to his qualifications or his expertise, that I think he was overreaching. And I think it all came through the longer he talked.
I did too. And I just, again, trust the jury, and then trust the people that they're going to believe the people. And I really believe this. They're going to believe the people that knew her before and after over any paid expert. So something else that I think is important in trial is that, trial is a battle of credibility, both with the jurors and with the judge. What are some of the things we did to make sure we showed our credibility?
Well, I think one thing that we did, which isn't always easy for a trial lawyer to do, is there were a couple of evidentiary rulings that went our way that we needed to correct, that shouldn't have gone our way. And you did a good job of letting the judge know with, for example, the learned treatise issue that came up. Tell us about what you did and why on that one.
Yeah, and it was such a minor issue anyway, but I proved up there was a document by the Environmental Protection Agency on what you need to do to safely operate one of these facilities. It's called a waste transfer facility. I call it a dump. And under the learned treatise rule, you can read it to the jury, you can show it to the jury, but it doesn't go back to the jury room. But the judge just admitted it, and it was going to go back to the jury room. I don't think it would have made a difference. The defense hadn't objected. It wouldn't have been reversible error. But I made a strategic decision one morning to tell the judge, before we go on record, Judge, the this was only offered as a learned treatise. It should not go back to the jury. These are the reasons. This is the law. And even though that wasn't in my favor, I told her that. And, then she corrected it and she instructed the jury that it's not going to go back, but that, and it all worked out. And one of the reasons I did that, though, is there were some really big legal issues coming up, especially on the directed verdict, where at one point the judge was thinking about granting a directed verdict against us. And I needed her to find me credible because we were right on the law. We had case law that was on our side. But I wanted her to see me as someone credible who's going to tell the truth on what the law is. So both that we could both defeat the directed verdict and both we can also get the language in the jury charts that was appropriate and not the inappropriate language the defense wanted to have. And so my thought is when I'm showing her that I want to be honest with her on what the law is, whether or not it is in my favor, I think that helped me gain credibility with the judge.
Well, if we're going to be bringers of the truth, we got to be bringers of the whole truth.
Yep.
Not just the facts of the case, but the law, the evidence, and I think that's important. If that's your mantra and your strategy going in, and that's truly who we are and who we want to be, we've got to be that all the time.
Absolutely. And it worked. That's the thing. It just, you go there and then, the judge, again, she's very, very smart. She always tries really hard to do the right thing. But one thing I learned is she thinks out loud. And so and doesn't really want you to interrupt her. She wants to go through it. And her thinking out loud when she was going through it, she was processing the defense's motion for directed verdict when we went home on Friday. So it was a long drive home.
Yeah.
And
a long weekend.
A long weekend. I had to really work on my mindset. But again, we had to trust. And that's one of the things I started telling myself is, two things. One is, I trust a judge. She's going to read the case law. She's going to do the right thing because I did know that we were right under the case law. And we had emailed cases to her and her law clerk to review. And the other thing is I said, well, while I believe I'm going to win this case, I'm going to hold my mind open for the possibility that there's some other grander purpose. And maybe it is I'm going to be even better by doing the things I'm doing for my next trial. It's going to help me develop whatever it is. There's some other grander purpose if I don't win the trial. And I'm just going to be open to that possibility. So I'm still going to give it everything I have. And I'm going to prepare. And it was hard to prepare when I thought to do my last two crosses, my closing, when I thought there might be a directed verdict. And then we went in first thing Monday morning, the judge calls us in like, we're going to go with the plaintiff's proposed charge with a couple of minor revisions. There's not going to be a directed verdict. And, some of the legal issues we're really fighting about, she had read our case law. She accepted it because it was right. And boy, it changed the whole feeling of that trial real quick.
It did. But again, just knowing that if you briefed the cases, you did the hard work, we researched thoroughly, we had all of the cases that we needed to have, and we had to trust that the judge is going to do her job and go through those.
And she did.
Now,
we also talk about credibility of our story. What are some things in our story, the way we told our story, that gained credibility?
Well, I think we had to embrace the fact that our client might not be the most likable person today because of the brain injury. And, I think that can be scary too for a plaintiff's lawyer who has a client that isn't the most easy person to deal with. And I think you did a really great job in voir dire touching on that. You started asking folks, whether they had people in their lives that they love, but they don't necessarily like. And I think that helped the jury panel start processing whether or not there might be people in the trial who had changed or they're, maybe not so likable because of her injuries.
Or even if it wasn't because of her injury. Just because you're not always a nice person doesn't mean you're not deserving of justice, and doesn't mean it's okay to hurt you. And I think that was something that was really important, just to start putting that in their mind, that, there are people that are lovable, that are worthy of love, but you don't always like everything about them.
Right.
And now, one thing that was kind of refreshing in this case, one of the potential worries in the case is that our client was a woman married to another woman. And even though we're in Austin, Texas, our Kelly Raymond, who was our brilliant jury consultant, told us that could be an issue with some jurors. And no one said it was in voir dire. We gave people the chance to go up and speak privately, although, our judge was pretty out about her sexuality. So I don't know how many people would have felt comfortable if they didn't like it. But the fact is, it didn't seem to make a difference at all.
I don't think it did. And, I lost sleep over it a couple of nights during the trial because, the jury makeup was pretty diverse. And I was worried that some folks on the jury had a moral opposition to gay marriage. And, our client had been married. She's in the middle of a divorce. And so, I didn't know if they were going to hold it against her or find it offensive. But again, we had to trust that the folks on the jury were honest during voir dire and that they were going to do the right thing. And they did.
And they did it shockingly quickly. I mean, it was my second trial in a month. So I actually drove home while the jury was deliberating because it's about 2 hours from the Austin courthouse to my house.
Did you
and
get
left
home?
you there to take the jury. And I didn't get home before the jury came back. I don't think.
I didn't realize that. Yeah.
No, I know. There was a note. I was home before. There was a note we got. And I think it was, and I still didn't know how to take it. There was a note we got that you texted me on, and my car has the voice to text or text to voice. And so I heard that, question 1, if it's a yes or no, do we have to write yes or no? And 2, for numbers, do we just write 1000000, or do we write 1 million? And so,
that's a pretty good question.
Yeah, I like that question now, but I didn't know for sure that they're still figuring out the charge. They haven't started deliberating yet, or maybe they got there. But I think it was they were out about 2.5 hours.
Yeah.
And they came back with, negligence on the defendants, only 10% comparative on our client, and $8.5 million. And it was unanimous, and it was quick.
Unanimous.
So I don't know what the dynamics were, if they had a strong leader, or it was just such a clear case.
I think that it was unanimous. Told me that it was a clear case. I think that they were able to put the pieces together very quickly. I think the judge helped us refine the case, and we were able to put it on very quickly. I mean, we had some witnesses via depot that we played 9 minutes long.
Yep.
I mean, literally get in and get out.
I think the only other thing to talk about is, when you're going through other incidents, because we were not able to get the past incidents in, but we were able to you got in discovery the videos of 2 other people that fell the exact same way at the exact same location. And then I found a case that said, if you're not offering it for notice, but to show that something is hazardous, it doesn't matter whether it happened before or after. And the judge she had some heartburn over it. She really went back and looked at it, and she read the case law. She had her law clerk read the case law. She talked to other judges, but we were right. And she says, well, it's coming in. I want to give the jury an instruction. It's for a limited purpose, but it's coming in. And I think that was really powerful because not only did we show our client wasn't the only one, but I think we were really able to normalize our client's behavior, because instead of putting things in chronological order, I didn't lie about times or dates or anything, but I showed the other 2 falls before I showed our fall. So we talked about what the dangers were, what the safest way to do it was. We showed photos where our expert went to other dumps that were set up safely and showed photos of safe dumps. And then we showed other people falling down, and then we showed our lady falling. I think that sequence made a huge difference.
Well, that sequencing was, going back to Kelly Raymond and her help in not just picking the jury. She helped with a couple of focus groups, you remember. And what we learned from those focus groups is that the folks on those focus groups were very much interested in other incidents. How had it happened before? What did those look like? Where had it happened? And so, I learned very early on from talking to those focus group members that to win this case, we were going to have to normalize these falls. It had to be something that this company had experience with. And so once we were able to sequence that in that way, I think that was, I think it made it real easy for the jury then.
And especially when they know that the defense refuses to do anything to fix the problem, even though I got their expert to admit on cross, or like 7 or 8 different things they could have done to fix the problem.
That's pretty infuriating.
Yeah. And, if they don't, the same thing could happen tomorrow unless the jury does something. And so I'm very proud of the jury for taking their role seriously and doing the right thing. So lessons learned. What are you going to do different for our next trial based on what you learned here?
Well, one thing that I'm for sure going to do differently is abandon this idea that I control things. And I have to just be open to the universe, delivering justice to my client, and understand that I've got to be the bringer of the truth and be prepared, like you were with those cases and be prepared with the jury charge. We did a lot of research on the exact charge we wanted. We pulled other cases and had other cases charges to show the court for examples. But I think being able to be flexible in your mindset when things go wrong is something that takes practice. And I'm going to work real hard for the next trial, just letting go of this idea that I can control all the details and that if they don't go as planned, that something terrible is going to happen. We just have to be able to roll with it.
I think the other lesson is, and I've learned this before, but I keep learning, is this: it's almost impossible to make depot cuts if you're going to show video depots too short. And I think one mistake we make is we look at every depot when we tell the story. You can tell from that depot, but you got to look at what are the stories you're telling from the other depositions. And so, like, you did a really good job setting up what this place looked like. But if you show that 6 different times, the same story with 6 different people, it loses its effect and it starts boring the jury. So I think just obviously you need to know what you want to prove and make sure you're proving what you want to prove with each of those depot cuts, but really trying to make them as short as possible because they're really hard for jurors to watch those videos.
Right. And I think that looking back, I think what we do as, lawyers, when we're the ones taking those depots, it's real hard to cut. It's like, somebody who's written a great American novel. It's probably very hard to cut a sentence out of a novel that you think is perfect. And so sometimes you got to hand your deposition over to a colleague and say, okay, cut out all the superfluous stuff because it's hard for me to do it. And you did a real good job cutting my beautiful long depositions down to 9 minutes.
But it worked.
It did work.
Well, Sonia, I had a blast trying this case with you. You worked up a beautiful case, and it was fun to come in and co-counsel it with you.
It was fun.
And I look forward to the next one.
Me too, Michael.
Look forward to the rest of y'all joining us next time on Trial Lawyer Nation. Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen, Rodriguez, Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.